Now we're going to move to departmental items. This is initiative petition 2050, Save Open Space and Agricultural Resources. Mr. City Manager or City Attorney, are you handling this one?
Yeah, this will be my item. So this is a voter initiative petition. It proposes a measure for the November 8th, 2016 general election. I should mention that this item was before you at your meeting on May 25th of 2016, and it was continued for further discussion this evening. For those of you who were here on May 25th, you will see some familiar information, but since there may be some who weren't here for that presentation, I'll review it once again. This slide here is a chronology which provides certain milestone dates of some of the events that have occurred with respect to this item. We have the original curb ordinance, which was adopted on November 3 of 1998, and it is proposed to expire on December 31 of 2020 unless it's extended. In a few minutes, I'll provide a little information about what the existing curb ordinance provides. You next see the date of April 7th of 2016 with respect to a notice of intention to circulate that was submitted to the city. I will mention that there had been a previous submission by these proponents earlier in 2016. However, there was a problem with the declaration of the circulators because it had been dated November 31 of 2015, which was before the date of publication of the notice of intention, and as a result there was a need to recirculate the petition, and that was done, and it was submitted on April 7th of 2016. Also on April 7th, the city provided a ballot title and summary, which I'm going to provide more detail on in a few minutes. That was prepared by me as the city attorney. On April 10th, the proponents published their notice of intention in the Ventura County Star. Publication of that notice is required under the Elections Code. On April 20th, the proponents submitted what's called an affidavit of publication to the city clerk. May 12th, the proponents submitted their signed petitions to the city clerk. The next day, city clerk submitted those petitions to the county. The reason for that is that the county would need to verify the signatures to make sure they were of registered voters. On May 17th, the county advised the city clerk that there were 4,867 signatures, and that exceeded the signature requirement of 4,024 for the November election. On May 25th, as I mentioned in my earlier comments, this matter was presented to the City Council to consider the options with respect to the proposed measure, and at that time the Council requested that the matter be continued to June 8th. That was actually based on my recommendation to allow some additional time for research to be done in connection with a letter which had been submitted on behalf of one of the property owners that I'll get to in a moment. So that's our chronology. In my earlier comments, I mentioned the title that was prepared in connection with this measure. The title is here on the screen, and it is an initiative ordinance that would be amending Chapter 3.0 of the city's general plan. In addition to the title, there is also something that's called a summary, which is also part of the documentation that I prepared on this matter. And as you can see on the screen, this was a citizens, and still is, a citizens initiative proposing to extend the date of the 1998 curb ordinance. I had mentioned that the current expiration date is December 31 of 2020. The proposed extension date is December 31 of 2050. All right. I had spoken earlier about the existing curb law and what it provides. This screen provides a statement of the existing law. Again, this was part of the summary that I had prepared, and it was submitted as part of the petition. As you can see, and as I mentioned earlier, whoops, too quick, we had on November 3 of 1998, the voters adopted the original curb ordinance. Secondly, that restricts growth within the city of Camarillo. CURB stands for Camarillo Urban Restriction Boundary. Thirdly, there's some exceptions to the CURB ordinance with respect to roadways, water facilities, public schools, and the other. And the curb ordinance expires on December 31 of 2020 and can only be amended under certain conditions. So that's the existing law. The proposed changes under the measure as it's been presented, I couldn't fit all 7 on one slide, so I've divided it. Here's the first 4 changes. I'm not going to read them all because they're up on the screen for you there. I'll just kind of summarize them here. It does establish, number 1, an area that's called the Caneo Creek Voter Participation Area. You will see a map that's one of the exhibits to the petition in a few minutes that will illustrate the location for that voter participation area. Secondly, it's going to require that changes to the general plan within that area, such as housing, be approved at an election or by the City Council under certain procedures. It imposes some additional notice requirements. It revises the existing exemptions for permitted development, and actually they're a little broader now than the previous ones, but essentially very similar exemptions, roadways, water and sewer facilities, public schools, and the like. So those are the first 4 changes. Changes 5, 6, and 7 are here. It extends the expiration date, as I mentioned, to December 31 of 2050. Number 6, it exempts projects where there's been a vested right. And finally, number 7, it would take precedence over any amendment that would be adopted between now and the submittal date. So that's a summary of the proposed changes in the current measure. I mentioned to you that there are certain exhibits to that petition. I'm going to spend a moment now and go through those with you. This is Exhibit A to the petition. It is the Camarillo Urban Restriction Boundary General Plan Map, CURB for short. And if you look in the lower left corner of the screen, there's a legend here, and the dotted red lines show the area that is the current Camarillo curb boundary. Then the solid black below that is the city's limit boundary, and then the final outline here are parcels. So going to the map itself, the dotted red line, as you can see here, does extend beyond the city limits in some areas, like right where I'm pointing here. So it is, my point being, in this area here as well, my point here is that the curb line and the city limit lines are not identical. All of the city is within the curb boundaries, but there are some properties that are within the curb boundaries that are outside the city limits. So that's the Exhibit A, the curb boundary general plan map. Now this is Exhibit B. Remember I mentioned earlier about the voter participation area. The slashed yellow, as you can see in the legend on the lower right corner, designates the voter participation area. To orient you to the map, this is the 101 freeway, Caneo grade coming down to the 101 freeway. We've got Pleasant Valley Road here, Poncho Road. There's an industrial area here in the middle that is not part of the voter participation area. So the voter participation area is, as you can see here, goes over to the area to the west and down. So that is the voter participation area. This is Exhibit C to the petition, and this is a copy of the city's general plan map. As you can see, the city's general plan provides a legend on the right. It's color-coded to particular uses within the general plan area. It does include properties that are outside of the city's limits for planning purposes, which is consistent with the applicable law. What I'm showing you now is the voter participation area. What this diagram or the map shows that is a little bit different than when you saw before is it's got the parcel lines. So the red lines here are parcel lines, meaning that it's a particular piece of property and the red line outlines that parcel. So for example, this area here is a parcel. And these numbers that you see here, these are the assessor parcel numbers that correspond to those parcels, sometimes referred to as an APN. Now, I mentioned up at the top that this is part of the voter participation area, the voter participation area, that would be part of options 1 and 2. And a little later in my comments, I'll explain what options 1 and 2 are. We did receive a letter on May 23 of 2016 from the Nielsen law firm on behalf of Cayugas Land Company. I'm going back one slide now. Cayugas Land owns this parcel here that I'm pointing to in the lower left corner, the southwest corner of the voter participation area. They also own a parcel of land which is immediately to the north of that. I think it's about 5 acres. By whatever size it is, that's what it is. And then there's a little strip of land just to the north of that we've been doing some research on. We haven't yet identified whether that's in the city limits or not because it's so close to the city limits. There's many title documents that we're looking at to determine whether that third piece of land is within the city limits or not. But we know for sure that the larger parcel here, which I believe is about 300 acres, and the smaller one to the north of that, about 5 acres, are outside the city limits. You'll understand in a moment the reason I went to that explanation. So now we have the letter from the Nielsen law firm. They represent the Cayugas Land Company that owns those parcels that I just mentioned. And they argue that the petition as it's been submitted is defective for 4 reasons. First, they say that there was a failure to publish the notice of intent and circulate it as legally required. Secondly, that the petition failed to include the full text of the initiative. Third, that there's false and misleading statements in the text of the initiative. And fourth, that the initiative and the petition failed to comply with other mandatory form and format requirements. So I've been busy for the last couple of weeks reviewing all this information and did a lot of research, and you're all going to hear about that now. First of all, on the argument with respect to the publication of the notice of intent to circulate, that's argument number 1 that they've presented. By way of background, as I mentioned in my earlier comments when I gave the chronology, on April 10th of 2016, that's when the proponents published their notice of intent to circulate the petition in the Ventura County Star. Now, I begin the discussion on the circulation issue with a citation to what lawyers often call a long-established law. When it's an older case, it's from 1920. But there are many cases since then. But this quote, I think, kind of captures the point here. And I'm going to actually read this. And I know that's maybe sound a little tedious, but I think it's important. So this is our California Supreme Court, the highest court in the state of California. And the name of the case is Application of Herman. This 183 Cal 153, that's where it appears in the official report. So what the Supreme Court said in this case is, I don't think I need to be pointing at it, you all know what I'm talking about. So by the term, a newspaper of general circulation, the legislature had in view publications to which the general public would resort in order to be informed of the news and intelligence of the day, editorial opinion, and advertisements, and thereby to render it probable that the notices or official advertising would be brought to the attention of the general public. So that's what the court described as the subject of newspapers of general circulation. So that's kind of an overarching point, and we'll see how that plays out as we go through these various issues. By the way, for those of you that haven't had the benefit of the agenda report, which is 200 and something pages long, the report itself is about 16 pages. The rest of it are attachments that establish the points that are made here in this PowerPoint and in the agenda report. So there's 8 points that I'm going to make, and I'm sorry this is going to take a little bit of time, but I think it's important for everybody to understand that this is a very serious matter. It is one in which Cayugas Land is making a contention, and I think that everybody needs to understand what the issues are that have been presented. So, in response to the issue, the first issue, their first argument about the newspaper of general circulation, and again, for those of you that want to read the agenda report and get more details, I don't want to spend the next 3 hours reading it to you, but I'll just summarize it for you here. Our first argument is that our first response to their argument regarding the newspaper of general circulation is, and by the way, their contention is that the Ventura County Star is not an adjudicated newspaper of general circulation in the city of Camarillo. So here's the. Did I say that wrong?
No, you said it right.
They caught it. Don't worry.
Okay. Well, sometimes
You said it right.
between my brain and my mouth, it doesn't always work. But
They're doing the same thing we did when we first heard it.
hopefully it did. Okay. All right. Back to the details. So the first response we have with respect to that issue is number one, is that the Elections Code 9205, when you read it, does not require that the newspaper be adjudicated as a newspaper of general circulation within the city of Camarillo. In fact, it merely says a newspaper of general circulation. I also point out in the agenda report that when the legislature intends for the newspaper to be adjudicated in a particular location, it will say so. And I gave examples of that. The probate code and other codes will specify where it needs to be adjudicated as a newspaper of general circulation, and this code section does not say it has to be adjudicated in the city of Camarillo. And by the way, the Ventura County Star has been adjudicated as a newspaper of general circulation for the county of Ventura, and that's the second point here. That the Star is an adjudicated newspaper for the county of Ventura as of June 23, 1952. And Camarillo was included, the Camarillo area, was included at that time as an unincorporated area of Ventura County. Most of you may know that the city was incorporated in October of 1964. So 12 years before the city was incorporated, the courts found that the Ventura County Star was a newspaper of general circulation for the county and for the area that at that time was the not the unincorporated area of Camarillo that later became incorporated. So here's another case, and being a lawyer, I'm sorry about that. I'll apologize in advance, but the cases are important to be able to understand what the law is on this issue. So here's a case a little bit later than the last one I gave to you. It's a 1964 case. It's Norwalk versus Call, and again, it's the California Supreme Court. And here's what they had to say with respect to this issue of the adjudication. That the purpose of limiting publications to newspapers meeting certain standards is to assure that the published material will come to the attention of a substantial number of people in the areas affected. Now remember, that's basically what that Herman case said that I had quoted to you from recently. But the reason I've included the Norwalk Call case is additional language here, which is, and of course, and I've gone to the trouble of underlining it and emphasizing it and highlighting it. It says, a newspaper meeting the standards does not forfeit its ability to serve that purpose merely because changes occur in the name or political structure of the area. So the fact that the city of Camarillo was not a city in 1952 and later became a city, it's my view that that would be a change of political structure, and the court is here saying that the newspaper, in this case the Ventura County Star, would not forfeit its ability to serve by the fact that the city later became incorporated. All right, so those are the first two responses on this issue. There's more to come. Number three, in 1936, the Star acquired the Ventura Free Press, which was founded in 1875. Now, the reason that's relevant is because the Ventura Free Press was a newspaper from what we can tell, obviously the records here are not as clear as they could be, and in fact the requirement to be adjudicated as a nursepaper of general circulation, I believe, did not occur until 1952. But the point is that the Star had acquired the Ventura Free Press in 36, and it had been founded in 1952. So that's the third point. 1875. Thank you, Charlotte. Number four, December 1993, the Star acquires the Camarillo Daily News, which was founded in 1926. Now, there are some documents that have come in what we call a red folder, and what that means is these are documents that we received after the agenda was posted last Friday. And one of those documents that came in is an order is entitled A Decree Establishing the Camarillo Daily News as a Newspaper of General Circulation, and that was signed by the court on August 15th of 1975. So for those of you that recall the Camarillo Daily News, it was here back in 1975 and operated as the Camarillo Daily News until December of 1993 when it was acquired by the Star. I've cited legal authority in the agenda report with respect to the legal effect of the acquisition of the Star, acquisition of the Camarillo Daily News by the Star, and that presumably once the Star acquired the Daily News, it would have acquired whatever rights and assets that the Daily News had, including the adjudication as a newspaper of general circulation. Number 5, talking about publications of notices. Now, before I get into some of the specifics on this one, let me mention that as I did earlier, and I've now cited a couple of court cases, that talk about the importance of a newspaper of general circulation in terms of presenting the information to the public and making it probable that they're going to become aware of it. One of the points that's raised in the Nielsen letter is that there's a newspaper that has been adjudicated as a newspaper of general circulation for the city of Camarillo, and that is called the Tri-County Century. So in the last 2 weeks, we've done some research trying to locate this newspaper, and to see to what extent it actually does publish any information that would be of interest to Camarillo residents. So, publication of notices. First, let's start with the Star. We know that 7 of the 10 cities in Ventura County use the Star for their publications. Now, when the Star received its order of adjudication in 1952, what it says in the adjudication is that it has been adjudicated for the city of Ventura, the county of Ventura, and the state of California. It does not mention the city of Thousand Oaks, the city of Simi Valley, the city of Camarillo, all of which were not incorporated as of 1952. So 7 of the 10 cities, there's a few of the smaller cities that use some local newspapers. I think Santa Paula is one.
Ojai and Fillmore.
Ojai and Fillmore are the other 2. But most of the others, well, all the other cities publish in the Ventura County Star. We know that the Ventura County Star is published daily. That would be 7 days a week. And that they're from, we checked the Star from May 27th to June 12th for that period, and we found 32 public notices in the Star during that time. All right, so we also did some research with respect to the Century, and we found that there's one city that publishes in the Century, and that's the city of Port Hueneme. And I should also add that Port Hueneme sometimes publishes in the Star. We also found that the Century publishes once a week, which is on Fridays, and we did a comparison of the similar time period for public notices, and since they only published one day this week, which was May 27th, there was one. So 32 public notices in the Star, 1 in the Century. All right, what about circulation? That's one of the indicia of whether or not a newspaper is one that's going to be widely read. Well, we know that the Star has rates for their subscriptions, that they're located in Camarillo in most of the grocery stores, gas stations, convenience stores, and the cost is $1. What about the Century? Well, you can access them online for free. There's no charge for the newspaper when you go to the news racks. It's one of those where you can just open it up and get it for free. And it's not located in any of the grocery stores, gas stations, or convenience. So obviously, if we're looking to which newspaper is most likely, based on circulation, to be one that's going to be available on any kind of a basis that's going to be widespread in Camarillo, it would be the Star. All right. So that's number 6. Number 7, information about Camarillo. Where do Camarillo residents, where are they going to look to find information about Camarillo? Well, we know that the Star has a website with a page dedicated to Camarillo. And how about the Century? Well, they have something they call a local page, which features public interest stories and information from different cities in the Tri-County area. That would be Ventura County, Santa Barbara County, and San Luis Obispo County. Dedicated page versus local page. What else do we know? That in 2016, and the city clerk's office staff has done this research, checked the articles on the Star about Camarillo. So we're now in June. Since January 2016, the Star has had 105 articles about Camarillo. The Century has had 4. So Before I get to the conclusion, let me mention there's another red folder item, which are articles on the curb and SOAR, which has been, is this posted on our website now, the articles yet? Okay. This was another item that came in after the agenda was posted on Friday. The city clerk staff, again, did some research with respect to articles that appear on the curb and the SOAR initiatives that have been the subject of obviously a lot of discussion over the last several months. And based upon that work, here's what we found. There were, from October of 2015 through present, there were 30 articles in the Star that discussed the curb and the SOAR measures. I went through all those articles and all these tabs you see. 19 of those articles included a reference to either specifically to Camarillo or to multiple cities, including Camarillo. So Camarillo was mentioned in 19 of those 30 articles. And so then the next check was in the Century to see how many articles they had on the curb and SOAR initiative since October of 2015, and the answer to that is none. All right. So what's the conclusion to be drawn from on the point of newspaper of general circulation? The conclusion is, number one, is that the Star is a newspaper of general circulation for the city of Camarillo. I think it's pretty clear from the evidence that has been presented here that it's the newspaper that is used by Camarillo and its residents to obtain information, and that the Star has provided that information. We also know that the Star is not widely distributed in the city of Camarillo, has very few public notices either by Camarillo or any other.
You mean Century.
What did I say?
You mean Century, not Star.
All right. Fortunately, I have the council here to correct me when I'm wrong. They do that a lot. All right. So the Century is not widely distributed in the city of Camarillo. And that since the purpose of a newspaper of general circulation, as I mentioned now a few times, is so that it is one that is going to be read, to be informed of the news, and to render it probable that the notices will be brought to the attention, it's clear that the Star is the newspaper that accomplishes that purpose. I've addressed the adjudication issue as well in the earlier comments. So that's argument number one. The others aren't going to take quite as long. This second argument by the firm with respect to the initiative as it's been presented is that they claim that the petition did not contain the full text of the initiative. And they have three arguments here. I'll go through them. And this is actually the only slide on this argument. So I know it's a little wordy, but that's just an occupational hazard for me. Number one is that Nielsen argues that Section 1 and 2 of the curb initiative are not included in the curb measure. That's their first argument. So here's the response to that. When you look at the petition, it says in the first paragraph of the preamble, accordingly, the following is the measure adopted by the voters and inserted into the city's general plan at Chapter 3.0. So that's what the petition said it was. That it was adopted by the and inserted into the city's general plan. So when you look at the city's general plan and how it was inserted, sections 1 and 2 from the 98 curb ordinance are not there. So there was no misstatement with respect to what was being included, and the voters would not have been misled by this. Secondly, they argue...
Mr. Attorney?
Yes.
When you say they're not there, it doesn't say curb or SOAR. It has the wording, and they are included. It just doesn't have the terms. Is that what you meant?
Yeah, no, here's what I meant. But thank you for asking that question. When you look at, and I should probably digress here for a moment. When you adopt an ordinance, often there are preliminary statements in it about the intent and such language, and I won't bore you with all the details, but when the ordinance itself, then the substantive terms of the ordinance are taken and they're put into the general plan, which is what happened here and what happens frequently. I mean, you could compare, for example, this code book that I'm about to hold up. All right, so this is like thick enough as it could be, right? Well, if all of our ordinances with all of their text were in here, it'd probably be about that much bigger. So when we adopt an ordinance, there's some preliminary language in it, but that isn't what ends up in the code. The substantive provisions end up in the code. So the point that I'm making here is that it said that it was going to incorporate the provisions that were inserted into the general plan, and it did do that. So there wasn't any misleading or misrepresentation there, and that's my conclusion on that issue. All right, second argument. That's this one here. Nielsen argues that Exhibit A to the curb measure is not the same as Exhibit A to the general plan, that Exhibit A to the general plan includes some additional information about the sphere of influence, areas of influence, and planning area. So let me go back. There. This is Exhibit A to the curb or to the current measure, and it includes the curb boundary, it includes the city limits, and includes the parcels. It does not include the other information that was mentioned by the Nielsen firm. So let me get back to that slide. All right, so we're on point 2. The responses that I have to this argument is, first of all, is that the Exhibit A to the measure, as I just illustrated it to you, is very detailed. It's more detailed than the one in the general plan area, and it also designates the parcels. And then the second point that I'd make is this. The fact that the Exhibit A to the measure didn't include the sphere of influence, the areas of influence in the planning area, I do not believe that they have made a showing that the voters could not intelligently evaluate the measure or that they would be confused by the measure. The measure clearly, sorry about all this, the measure clearly identifies, first of all, in Exhibit A, the curb boundary, which is not changing, and it clearly identifies the voter participation area. So voters were aware of what the information was that was necessary for them to make a decision in connection with this measure. The fact that it didn't have some other lines that go further beyond the city's, like here, for example, I'm showing you Exhibit C, that it didn't have some other dotted lines that were the of influence, or that there might be some additional information that could have been included in the map. Is that something that either misled the voters, prevented them from being able to evaluate the measure, or would cause confusion? And I don't think it would. All right, to pick up where we left off, the third argument is they say that the severability and amendment or repeal sections are not stricken. And I'll have to try to think of a way to explain this that makes some sense for a change. A severability clause basically says that if there's a portion of an ordinance that is stricken out, let's say you have 10 provisions in the ordinance and some court finds that one of the provisions is unconstitutional or illegal, that the remainder of the ordinance would remain in effect. So that's what a severability clause is. Amendment is, as it implies, how do you amend it? And repeal, again, that's fairly understandable that would be, you would repeal the ordinance so it would have no effect. So what the measure did do is say that those sections, well, first of all, the severability, amendment, or repeal sections, remember I explained earlier about how we were talking about what was in the general plan. Well, those aren't in the general plan, so the fact that they aren't referenced in the measure, to me, is irrelevant, and certainly doesn't create a defect that would warrant rejection. The measure does say that it is replacing the original in whole after all of those provisions. So after the repeal section and after the amendment section and after the severability section, it says replacing the original in whole. So I think that's pretty clear about what was intended there. And finally, as I mentioned before, there's been no showing, I believe, that the voters would not be able to intelligently evaluate this measure because of the severability amendment and repeal sections for the reasons I've just said, or that they would be confused. So that was the second argument. The third argument, this is one that I'm debating whether I should go back to the slide of the map or not, but I'm not going to. I'll use my words. As you recall, there was the portion of the voter participation area in the lower left corner, the southwest corner, that was outside the city limits, the land owned by the Callegas Land Company. And what they're saying is, as I understand it, is that you cannot include the Callegas land property that is outside the city limits with this measure. And my answer to that is that that's not true. You can plan for property that's outside of your city limits. So the first point being that the measure itself says, in reference to subparagraph H, it clearly references the, and that slide doesn't really give it context, so if you'll bear with me for one moment, I'll find that. I didn't have room on the slide. Found it. It's section H. It's on page 3, and it's talking about within the Conejo, I'll quote it, section H, quote, within the Conejo Creek voter participation area and in any and all applications for a zone change or project that require a public hearing, whether before an officer, board, commission, or council of the city. So it's clear, in my opinion, that this measure applied to projects that were brought before the city. It says that. So that's my first point, is that we are dealing with a measure that's dealing with projects that are being brought before the city. The fact that the property may be in the county now, we don't know that it's always going to be in the county. As long as it's in the county, clearly the county has jurisdiction over it, and there's nothing in this measure that says otherwise. The second point that I make here, and I do this because the Nielsen letter raises it, is that this somehow is affected by LAFCO and that there's some interference by the measure with the LAFCO rules. Well, that's not true. There's nothing in the measure that interferes with LAFCO or that even suggests that it's trying to interfere with LAFCO's rules. Now, let me pause for a moment and explain that LAFCO is the Local Agency Formation Commission, and that if and when the Callegas land property were ever to be annexed to the city of Camarillo and possibly be subject to our process, it needs to go through what's called the LAFCO process, and they would review it to determine whether it could be annexed into the city of Camarillo. LAFCO does a lot of other things, and I don't want to minimize their role, but whatever it is they do, there's nothing in this measure that interferes with LAFCO's powers or jurisdiction. And the third point is that cities may include areas outside the city for planning purposes. I'll be with you in 1 minute. All right, I'm back. The Merritt versus City of Pleasanton case, which I've cited here from 2001, this is in the agenda report at the bottom of page 7, and I do want to read just the last sentence from that case. I'm quoting it. Until the city acquires the property, the city cannot zone it. Indeed, the whole purpose of pre-zoning is to designate the zoning that will occur upon annexation. So, based on the court cases, based on the fact that cities do plan beyond their city limits, the fact is that the city of Camarillo has planned beyond our city limits in our general plan. There's nothing that is illegal about that. There's nothing in the measure that would give rise to that being a defect in the petition to warrant its rejection. And I would also call attention to a government code section 65859, which talks about pre-zoning of unincorporated territory. So the conclusion on this point being that there is no false or misleading statements in the measure. And now I'm on the fourth argument, and this is the last one. I don't know how many of you saw Johnny Carson, but we did a Karnak thing with the envelope, and it'd say, this is the last? Okay. The initiative petition did comply. Well, for those of you that weren't around for that, you don't understand that reference, but...
I think most of them were.
Well, they may be. I see some young faces. So the fourth argument is that the initiative petition complied with all requirements. So what the Nielsen letter does is at the end they kind of throw in a few other arguments to suggest that there might be some issues with the petition. I've reviewed those, done the research, and I do not find that there's any of those arguments that would warrant the rejection of this petition as being defective. They first argue that under the Elections Code Section 9203, that the petition language didn't include before the title and summary where it says, the city attorney has prepared the following title and summary, and then of the chief purpose of the endpoints of the proposed measure. So they're saying because these words, the chief purpose and points, weren't in the measure, that we should find that the measure is defective. Well, the answer to that is twofold. Number one is that the lack of that language, there's no evidence, in my view, to show that the voters could not intelligently evaluate this measure because of the lack of those 6 words. And secondly, under the doctrine of substantial compliance, I think there's been substantial compliance. I'm going to tell you in a moment about that doctrine of substantial compliance. The second argument that's at their end of their letter is that Elections Code Section 9224 references what's called an enacting clause, and that the ordinance must include the language, the people of the city of, and it would be Camarillo, do ordain as follows. So those words right there. And they say that's not included in the petition. So here's our responses. First of all, that enacting clause is included in the proposed ordinance that's in the agenda packet. So the ordinance that would be presented to the voters would have the enacting clause. The second point I will make is that the lack of those words, there's no showing that the voters could not intelligently evaluate the petition or be confused by the lack of those few words. And finally, under the doctrine of substantial compliance, I believe that there would be substantial compliance. All right, I've been previewing this one, so let's get to this doctrine of substantial compliance. Here's another California Supreme Court case. It's called Costa versus Superior Court, decided in 2006. And as boring as this is going to be, I'm going to read from this quote, from this case now, because there's many statements within this quote that I think are relevant to the matter that's before the council this evening. So it says, at the same time, as we shall see, the governing cases also have recognized that an unreasonably literal or inflexible application of constitutional or statutory requirements that fails to take into account the purpose underlying the particular requirement at issue would be inconsistent with the fundamental nature of the people's constitutionally enshrined initiative power, and I have underlined that for emphasis, and with a well-established judicial policy to apply a liberal construction to this power whenever it is challenged, in order that the right be not improperly annulled. If doubts can reasonably be resolved in favor of the use of this reserved power, courts will preserve it. And then there's a citation to some cases. And the last case, they say, the Epperson case, emphasizing the fundamental concept that provisions relating to the initiative should be liberally construed to permit, if possible, exercise by electors of this important privilege. I also emphasize that. And there's more. The court, this is also from the Costa case. Thus, when California courts have encountered relatively minor defects that the courts find could not have affected the integrity of the electoral process as a realistic and practical matter, past decisions generally have concluded that it would be inappropriate to preclude the electorate from voting on a measure on the basis of such a discrepancy or defect. In such cases, as long as the fundamental purposes underlying the applicable constitutional or statutory requirements have been fulfilled, the decisions have concluded that there has been substantial compliance, underline emphasis, with the applicable constitutional or statutory provisions, and that the invalidation of a petition and preclusion of a vote on the measure is not warranted. So that is the doctrine of substantial compliance. And what that would mean is that you don't always have to turn square corners, that if the so-called defect is one that you could say that there's still been substantial compliance with the purposes and intent of the statute, that is sufficient. All right. Now, this is, well, I need to get to option 1, 2, and 3. Here, I'll come back to option 4 in a minute. So, the agenda report has, as it's been presented, 4 options for consideration by the council. Option 1 is to adopt the ordinance without alteration. Option 2 is to submit the ordinance as it's been presented without change to the voters. Option 3 is to order a report per the Elections Code 9212. And option 4 is submit the revised ordinance to the voters. So now I'm going to go back to this last slide. It is discussed in the agenda report with regards to a possible 4th option. This 4th option, I'm going to summarize it briefly here. This slide, as you can see, voter participation option 4, would modify the voter participation area by deleting the property that's located outside the city limits. That would be the Cayugas land parcel ending with 0080 here. I can't read what those numbers are, but the one that I said was about 5 acres to the north of that. And then if there's that other sliver of parcel that's north of that, if that's outside the city limits as well, that would not be included in this revised voter participation map. So let me point you to the legend here. The revised ordinance with the voter participation area would be here. This one has the parcel lines that I told you about before, affected parcels, and the city boundary is in bold and black. So that is option 4. And I told you before that there's 4 options, or other action is deemed by the council to be appropriate. Now, in addition to the red folder items that I've mentioned previously in my comments, the council has also received, and it's been posted on the city's website, and it's in the category of what I call the red folder items, multiple emails from residents with respect to their desire that the council consider the measure as it's been submitted. That meaning that none of, and I believe there's about 50 or more emails.
57.
50. Thank you, my assistant. So we have 50, plus or minus 57 emails from residents who have all indicated their support for the measure as it's submitted, and nobody indicated support for measure number 4 or option number 4. Now, the reason option number 4 is been presented in the agenda packet as an option is that there were discussions that I had with the attorney for the proponents and the attorneys for Cayugas land to see if there was a way to resolve the issues that have been presented with respect to the challenges to the measure as to whether or not it was legally defective or not. However, in order for option 4 as a compromise, if you will, to be feasible, it would be necessary, in my opinion, that there be community support for it. And given the number of emails that have been received with respect to the community's desires to have the measure submitted unaltered, in my opinion, option 4 is not a feasible option. I would suppose some of you sent those emails in. So I believe that you have a city council here that is certainly aware of the provisions here and sensitive to the desires of the community. We're also sensitive to the requirements of the law. And if this compromise is one that is not being supported by the community, it's certainly one that is not a compromise. In order to have a compromise, you need to have it supported by the necessary parties, and if the proponents of the measure and their supporters are not in favor of it. It's just not going to be a feasible measure. So it was presented as an option, but at this point it doesn't appear to be one that's feasible. Let me talk about option 3. Option 3 is one where the council could order a report. We'll get to questions in a minute. This is Elections Code Section 9212, and one of the options that the council has is to request a report where you ask about the fiscal impact, to check on internal consistency, the effect on land use, the impacts on funding, the community's ability to attract and retain business, the impact on vacant lands, the impact on agricultural lands, any other matters, and that it's going to be presented no later than 30 days. This is not an option that would appear to be a reasonable one in my view, given the fact that there doesn't appear to be any questions with respect to what this measure provides. The report is intended, and I believe that this Elections Code section is intended when the council believes that that information is necessary for them to make a decision. Now, having said that, that's my view, and I'm not one of the voting members up here. So the council certainly has a choice as to whether or not to request that report. So it was my obligation to present that as an option. But given the analysis that has been done here and based upon my review of the measure, it doesn't appear that there's a need for that report, but certainly would defer to the council if they should make that choice. So now let me go back to questions. These will be questions from the council, not from you all.
I have a question.
Questions?
Your
Yes, Charlotte?
Yes, you said one thing and then you later said something about adopting it, not adopting it, but putting it on the ballot unchanged. And then you said the what you were suggesting would contain the words, "the people do ordain," or something like
Yes.
that. How do you reconcile those two things, unchanged and adding those words?
Well, I would reconcile it by saying that the Elections Code says do ordain, so it's my belief that we should put that into the ordinance. So technically, yes, we're adding language to it, but I believe we can do that because it doesn't change the text of the ordinance, because all it is it's a so-called enacting clause, but the text of the ordinance as it was presented to the public and as they reviewed it in the petition is the same. It's just that we have that introductory sentence, if you will, where it says do ordain. And as a matter of fact, and I'm glad you asked this question, if you look at the section 3.0 of the general plan, which is where this would end up, it doesn't have the enacting clause in it or any of the other introductory paragraphs.
Thank you.
Any other questions? Kevin?
Yeah, just kind of quickly, Brian, on your eloquent nature going through this. But in your opinion, then the questions that were brought up at the last minute, that we do have answers to them, and you're comfortable that with your due diligence that you've looked at a number of case law to be able to answer those in a reasonable and a timely manner?
Well, let me answer it this way. The answer is yes to your question, but I would add this, that, I'm the city attorney, I'm not a judge, and I cannot predict what would happen if there was a court challenge that would be filed to the measure as it's been presented. I did, to the best of my ability, do a review of the facts and of the applicable law, and my conclusions are that the defects that are referenced in the Nielsen letter are not a sufficient basis for the council to find that this is a measure that should not be put on the ballot. But as I said, if there's a legal challenge filed, it is certainly possible that a court could view the law or the facts differently than I have. But I have done my best to come to the conclusions that I have with reviewing all the arguments, the documentation, and the applicable law.
Thank you.
Mr. Mayor,
Mr. Little?
these are one of the times where our city attorney earns his money.
One of the many times.
You see what we get to hear in the back room from him?
So I thank you for that explanation. I hope the residents and voters and citizens in the audience understood because it was well done. I think
That's one for our attorney.
Rarely does he get applause.
That's right. But in any event, I just want to thank the city attorney for the presentation, and I think it answered a lot of questions. I hope it answered. It certainly did for me when I heard it, and I hope it did for the other people in the room. So with that, I guess we go into some public comments or something.
Wait, any other comments? Any other questions? Okay, we'll open the public hearing. We'll take public comments at this time.
It's not a public hearing.
Tad Doherty. Remember, Tad, take into consideration what the attorney just said. All of that.
Good evening, Mayor and council members. First, mirroring your own comments, I would like to really compliment the city attorney on his very thorough agenda report. What he summarized there was a lot of it, but the written 16-page report was in-depth, thorough, and really comprehensive, and I really appreciate that. At the risk of being slightly redundant, stripped down to its bare essentials, a local voter initiative is really a pretty simple process. Some members of the public would like to have a law put into the books, so they draw up an initiative measure. Then they circulate petitions within the city for eligible voters to sign to show that there is the necessary support for the initiative to go forward. Once those petitions are submitted, county elections officials verify that the measure has received the required number of signatures and that they are the signatures from registered voters from within that city. The officials certify that to the city. At that point, the initiative measure is presented to the City Council for it to take a specified action as outlined in the state election code and which have been shown in your agenda report. And that is where we find ourselves tonight. We have done all that I just mentioned. We have met all those criteria. Now, we are here to simply bear witness to the action that you will take as you are obligated to do under state election code laws. We urge you to go forward with option 2 and take this initiative and put it on the November ballot. And for us, the proponents, of which I am one, option 4 is a non-starter. We have not agreed to and will not stipulate to any changes in the initiative. Thank you.
Excuse me, Your Honor. I have
Yes,
one question.
Ms. Craven.
You said you wouldn't agree to any changes. Would you object to adding the words "the people do ordain"?
There's no problem with that. That is just as Mr. Perrick explained.
Exactly.
I'm just wanting to ask.
Okay.
Next one, Bob Merrilies.
Mr. Mayor, council members, thank you. I'm going to be brief and talk about some of the conclusions that were made in the last couple of weeks, actually. On page 10 of his report, Mr. Perrick concludes, based upon our analysis of the Nielsen letter, we have concluded that the arguments raised by Nielsen do not warrant the rejection by the city of the petition for the proposed curb measure. The other conclusion was made 2 weeks ago by the mayor, when he said they're going to sue us anyway. I'd bet on it. And finally, I'll close with the fact that I too am a proponent of this, and I too will not stipulate to any amendment to the ordinance except
The one?
the one.
Which one did you want?
We the people do ordain and establish.
Okay. Thanks, Bob.
Thank you.
Next, Marge Lorraine. Seems like I've heard you guys talk before.
Good evening, City Council members, Mr. Norman, and especially the City Attorney. I will probably be redundant, but I worked on this afternoon, so I'm going to read it. Anyhow, my name is Marge Lorraine, and I live in Leisure Village. I respectfully ask the council to approve option 2. When Save the Grade was organized 7 years ago, that was our intention, to save that beautiful land for prosperity. When we began collecting signatures for our petition, twice, that was what our signers heard. The passion people felt for that land was overwhelming. People from other cities became testy and irate when they were told only Camarillo residents could sign. 2 people from LA County asked me if they could sign. Those of us who collected petitions, who walked from house to house and apartment to apartment, and sat in the library and stood in the farmer's market, showed everyone the map and the land to be protected. We were hiding nothing. They knew and understood and concurred with what we were doing. For us to waver in supporting option 2 would be a betrayal of our values, but what would be worse, it would be a betrayal to all of those who believed in us. Please put option 2 on the ballot and give the citizens of Camarillo the opportunity to decide the future of this spectacular space. Thank you.
Thank you very much.
Your Honor,
No.
Your Honor, let's explain why we don't have clapping after individual people. We want to hear from everybody, and if there's somebody in here who has a differing opinion, they should not feel intimidated. So we ask people not to clap, and we ask people not to boo.
Sean Welch.
Good evening, Mr. Mayor, council members. My name is Sean Welch. I'm a partner at the law firm Nielsen Merksimer. I specialize in initiative and election law. Tonight, I think it's important for the record to reflect that there's only one lawful option before this council and the city of Camarillo, and that is to reject the initiative petition because it plainly violates the California Elections Code. To be clear, options 1 through 3, included in the agenda material tonight, would violate well-established law. Now, I know you received some legal analysis in your agenda packets and tonight from the city attorney, and unfortunately, I have 2.5 minutes left. I can't go point by point, but I'm going to leave you with 3 important legal points. The first, what's been presented to you is simply not the way that initiative publication and posting requirements work, nor is it an accurate discussion of the law as pertaining to newspaper adjudications. Namely, there is a Court of Appeal case. It is called Ibarra versus City of Carson. It's prominently cited and outlined in our letter of May 23. In that case, the Court of Appeal invalidated an initiative measure because the proponents published in a paper adjudicated for the county and failed to post in 3 public places. It's directly on point with the facts here, yet it's not even mentioned once in the legal analysis you received. It's a problem. Second, the analysis you received concedes there are full text problems in the initiative petition, but claims that there's no proof or evidence of voter confusion. That's not the law. Again, your analysis is missing. There's cases, including Heber v. Bybee, also cited in our letter. Court of Appeal, California, has held repeatedly that there's a presumption of voter confusion when the full text rule is violated. There's no proof necessary. There's no declarations. You don't go around asking voters what their opinions are. It's not the way it works. Third, it defies both the constitutions of the United States and California, as well as logic and reason, to think that a municipal initiative could ever lawfully impose voter approval requirements on property outside the city's jurisdiction. The right of initiative is constitutionally limited to legislative acts. Imposing an illusory and ineffective voter approval requirement for uses of land outside the city is simply not one of them. It's not only the law, it's common sense. Any judge in any court will understand that. Accordingly, I urge you to consider the matter before you tonight carefully and take the following actions. 1, reject the legally defective initiative petition as required by law, and if you so desire, in line with option 4, consider an alternative measure, a council measure that would extend the SOAR timeline, and 2, exclude property that is unlawfully outside the boundaries of the city that's currently in the present measure. If you have any questions, I'd be happy to answer them, but my time is almost expired at 4 seconds.
Mr. Mayor.
Mr. Little.
You mentioned these text issues that you say the city attorney's apparently just shrugged off as far as you're saying that they really mean what they mean. Yet at the time, your final conclusion was you would be satisfied with option 4 by excluding the property. You don't mention the other text measures. Are you talking about, well, you just keep them shrugged off or what?
No, Councilmember Little. The measure that you would place on the ballot would be a council-sponsored measure. It would have nothing to do with this initiative. You could draft it tonight or in the coming weeks any way you wanted to. Completely separate process. The current measure, invalid, ineffective, if it's placed on the ballot, it's my view that a court's going to take it off. Alternatively, and nothing's going to be on the ballot for November. Alternatively, the council, if it so desires, could construct an alternative measure. The rules about the form and format requirements, all the legal defects, publication, the posting requirements, it all goes away because this becomes a council measure. Something would be on the ballot for November, but it would be consistent with the law.
Thank you.
Other questions? Thank you for your comments.
You're welcome. Thank you.
Luis Roberts. Don't leave. It's just getting exciting, guys. Luis Roberts. Oh, there you are.
Good evening, Mr. Mayor and City Council members. My name is Louise Roberts, 2441 Blanchard Place. And as you can see, we're all here again. I'm the founder of Save Conejo Creek. Over the last 9 years, hundreds of Camarillo citizens have packed your chambers time after time to let you know how important our magnificent gateway into Camarillo is. Most recently, over 6,000 voters signed the petition for the Camarillo SOAR initiative, not once but twice. We've worked too hard, too long, and come too far to watch it be torn apart now because a high-powered law firm hired by Callegas Land Company, a development company which has land in the VPA, has claimed that our initiative petition fails to comply with numerous mandatory requirements of the California Elections Code. We all know that a good law firm can pick apart any document, but please keep in mind the liberal construction of initiative power that Mr. Pirek on page 2 states in his report. The California Supreme Court has said that the initiative power must be liberally construed to promote the democratic process. Indeed, it is our solemn duty to jealously guard the precious initiative power and to resolve any reasonable doubts in favor of its exercise. Well, they threw everything they could come up with against the wall, hoping that some of it would stick. I want to thank and commend the city attorney, Mr. Pirek, and his staff, and Jeffrey Madeline and her staff for the exhaustive work that they did in reviewing and researching the allegations brought up at the last minute and finding that there was no merit to any of them. The SOAR initiative has been found to be sufficient, so according to the state election code, it must be placed on the ballot, unaltered. Conversely, there is no reason to place option 4 on the ballot because of threat of lawsuits. The people of Camarillo have spoken loud and clear time after time. We implore you, the elected representatives of the people, to protect the gateway into Camarillo, in fact, all of Ventura County, the amazing vista that sets us apart from the San Fernando Valley and Orange County, keeps our identity and defines our character. Don't let a lawsuit, the threat of which has so aptly been quelled by your staff, define what you decide tonight. Take note that even while Mr. Pirek discusses option 4 to remove the land from the VPA, he states, and I quote from page 10, based upon our analysis of the Nelson letter, we have concluded that the arguments raised by Nelson do not warrant the rejection by the city of the petition for the proposed curb measure. It's in your hands. Please listen to the people of Camarillo and to your staff. We implore you to select option 2, place the unaltered initiative on the ballot, and discard option 4. Thank you very much for your consideration.
I have a question.
Question? Charlotte?
Same question I asked Mr. Mariles and the other gentleman. Would you object to those 6 words being added?
No, I would not.
Thank you.
Thank you.
Pat Brown. There's a famous name, Pat Brown. Live up to that, Pat.
Well, I won't govern you.
Yeah, wrong gender, but...
Hi, this is Pat Brown. I'm going to say it's with an E, so I'm not going to be a governor today. I am an RN, however, and I wanted to say hi and thank you for letting me speak out. And I want to tell you my little OCD soul was wonderfully given lots of information by Mr. Pirek. As an RN, I'm going to talk to you about informed consent. None of you ever wants to go into a hospital or any place and just have people just do things for you. And you like to be told what's going on, and you like to be able to give consent, every single one of you. Informed consent is my stock and trade as far as an RN. I'm going to ask that you, as city councilmen, have even a more important job than physicians and attorneys on an individual basis because of what you do, that you will inform our population, allow them, you've given us informed consent, and then allowing us to choose. Thank you for that, and I ask that you keep option 2 with the 6 words on it and go from there. Thank you.
Thank you. John Dempsey.
Hi, my name's John Dempsey, 2159 Derby Street. I'm the CEO of 2 LLCs and 1 sole proprietorship in the city of Camarillo, and I'm proud to say that 2016 is our best year ever. Part of the process in setting up any company in Camarillo is that you need to file your fictitious business name, or FBN, form at the county office, and then publish your FBN notice, choosing from a list of adjudicated newspapers of general circulation. California Code 17924 states, and I quote, "The statement should be published in a newspaper of general circulation in the county where the principal place of business is located." With regard to SOAR, Election Code Section 9205 states, and I quote, 9205, "A notice of intention and the title and summary of the proposed measure shall be published or posted or both as follows. A, if there is a newspaper of general circulation as described in Chapter 1, commencing with Section 6000 of Division 7 of Title I of the Government Code, adjudicated as such, the notice, title, and summary shall be published therein at least once." In 1975, the Camarillo Daily News was challenged by Caligas Land Company in Superior Court. On August 15, 1975, the court ruled that the Camarillo Daily News is a newspaper of general circulation and for the city of Camarillo. In 1993, the Star acquired the Camarillo Daily News and in turn became an adjudicated newspaper of general circulation for the city of Camarillo. SOAR did publish their notice of intention in the adjudicated newspaper of general circulation, the same newspaper of general circulation identified in the Superior Court order, the same newspaper of general circulation used to file an FBN in Camarillo for my businesses. If there is going to be a problem with defining whether the Ventura County Star, which physically is located within the Camarillo city limits and has the highest subscription rate of any Ventura-based newspaper in the county, is, for whatever reason, not an adjudicated newspaper of circulation, then such a ruling will impact much more than SOAR. It will impact all businesses who will need to refile their FBNs. Now, that's just not going to happen. I asked the City Council to carefully review the agenda report submitted by our City Attorney, Brian Perrick. As a SOAR rep, we acknowledge and agree with all 8 points he writes about with regard to the Election Code Section 9205. We ask the City Council to go with option 2 to place the SOAR initiative on the ballot as is. Thank you for your time.
Thank you very much. Now, somebody I've known for a long time, but I thought that must be your office, not your place in Ventura. Richard Francis.
Thank you, Mr. Mayor, members of the council. It's a pleasure to be here again this evening. When we were here 2 weeks ago, and we put it off for 2 weeks so that Mr. Pierrick would have a chance to look through it. It sounded like 2 weeks was plenty of time. What it turns out, however, is that there was a holiday in the middle, the Memorial Day holiday, and then we also learned that he has to turn in his report pretty much a week early. So we had less than a week, really, to do this analysis. So it was an incredible job that he was able to pull all this together. I want to address 3 things tonight. The options, your staff, and the proponents. The options, option 1 is to adopt the measure as it's been presented to you. It seems counterintuitive that we would prefer that you not do that. It would be easy. But as I explained to Councilmember Little 2 weeks ago, this is a voter participation process. And we encourage the voter participation. So option 2 makes much more sense to us than have you just hand us something on a silver platter. It also is important that Camarillo engage with the symbiosis. We've got a county measure that's going to go off at the same time. So it's important that all of this work together. The voters have a right to speak. With respect to option 3, we know what SOAR is. There isn't really a lot of secret. It's been around for almost 20 years. And with respect to option 4, I want to again thank Mr. Pierik for taking the laboring oar at trying to work out some kind of compromise in case everything else fell apart. I know how much time I spent on this over the last 2 weeks, but I was only dealing with one part of it. Mr. Pierik was dealing with not only me, but he was dealing with the Nielsen Mercksammer firm as well, and his own staff and his own research. I don't know whether he was, it's the only public employee that I know that I was able to speak to on the Memorial Day holiday. It really was incredible. So with respect to the others, we do commend you to go with number 2. Staff, Ms. Madland and her staff, I wasn't aware of that until I read the staff report, how much work they put in. Not just Mr. Pierik's office, but your staff took this on and ran with it. And then with the proponents, I have worked diligently with every city that's got a SOAR measure going. All the citizens and the county. This has been my baby with a board that I work with. Your citizens are unbelievable. They are the best, and I commend their recommendation to you.
Thank you. That's okay. He does a good job every time, especially the first SOAR. Remember our first SOAR? We have, yes.
I just want to say I don't always agree with Mr. Francis, but when his comments about our citizens, I will agree with.
Yeah. Last speaker. Last speaker. Mr. Matt Lorimer. You got to speak to this one too, huh, Matt? Go ahead.
They always say, well, here I am. Let's see why we're here. If you work and you come down that grade and you spend 45 minutes, you know that it's getting crowded in Camarillo. You're tired of all the building. There's been a lot approved by this city council, and they're tired of it. You guys are even thinking about building a convention center, bringing 500 or 1,000 more cars in this community. The community's had enough. They don't want it. They've basically put this initiative on the ballot because they want to control it. They're taking the control away from you, and they're taking control because they don't want Los Angeles here. If you've ever been to Los Angeles, you see what's going on. Crime, traffic. It's pretty bad. They don't want it over here. And by the way, crime is up 18%. Assaults are up 33% in Camarillo. You can make all excuses and shake your heads, but something has happened in Camarillo. So as we look at this, these people have had to take their time away from their lives, knocking on doors for several months, coming here, and now they have attorneys outside the town who want to disenfranchise them as voters in this city. Outrageous. These people have paid taxes, they live in this city, they don't want it, they've spoken up, and they've had enough. And so therefore, you should follow the people, because the people are the city. Now, you have option 2. You should follow option 2. And you know something? The voters have an option 5. And you know what that option is? Recall the city council if they don't listen to the people in this city. Laugh and shake your heads, but this is a serious issue. They care. They spent their time, months and days. You've heard them. A lot of these people are retired. You know something? I think it's great. They took the time to do this because they care. They've seen what LA County is, and they don't want it here. And you know, for the builders and developers, you know, they say they create jobs. They come from the valley. They're not in this area. And the people who are looking for homes, most of these homes that are being sold are not Camarillo residents, okay? So if they want to look for more building, maybe they should look in LA County, because that's where they belong. The people here have spoken loudly and clearly tonight. They don't want that stretch of land coming down the highway with homes on it. So hopefully you will listen to the people tonight. Thank you.
Any other questions? Any comments? No, good. Well, we have no more comment cards. Now we're taking any kind of questions?
comment, I think.
Comments? No questions, comments. We've been through this long presentation. Our attorney's good back there, too. And so we like it. But Charlotte?
Yeah, I went through all of the emails that were sent, and there were 45 of them. And then there were 12 more of the yellow cards, which are comment cards. I didn't add up the people who spoke. I don't remember how many. But there was a total of 57. And then, 50, with the 12 that came in just before City Hall closed today, there were 57. And then 7 more yellow comment cards, bringing it up to 64. Of those 64, 20, 30, 43 wanted us to put it on at number 2. And the people who had been part of the organization have all said it doesn't matter to them. It's fine if we add the 6 words, the people do ordain and whatever that the attorney said. I'm not sure how that's going to work, but at any rate, out of all of them, we had 2 people who didn't want it put on. There was 1 out-of-towner. I didn't really count that in my totals. And there was 1 person who submitted 2. So it seems to me of the people who chose to participate, there were 4,867 who signed. There are 37 who would like us to put it on as number 2, and there are another 10 who wanted us to do number 1 or 2. So it seems to me that it's a pretty simple thing. The people who want this to go before who want it to go before the voters, and I think that's what we need to do, is put this before the voters.
Jen?
First, I want to take the opportunity to thank our staff for their hard work. Yes. We don't often, in fact, I don't remember the city attorney ever getting that much applause.
Now you can clap.
This is his night. Yeah, give him an applause. In fact, I remember there's been some boos, probably from some of the same people out here, but that's okay tonight. You love him. But anyway, I wanted to thank you and all of the staff who worked so hard on this, because it was, 2 weeks ago we put off this decision to make sure that we had covered all our bases that we could do. So I thank them all for that. Personally, I believe that the citizens of Camarillo deserve the right to decide this. It needs to be put to the voters. I applaud all of you who have worked so hard to bring this forward. It really is, when you get something that you believe in and you work so hard for it, it really says a lot about our community, and we thank you for participating. And now it's time to let the rest of the community, the rest of the voters, have their say. So I certainly can support sending this on to the voters in November.
Bill?
Well, I think I made my comments already, but I'm prepared to support the placing of it on the ballot, or
hang on a second,
referring it to the ballot for the voters of the city to consider.
Kevin?
Yeah, it may not have been popular with everybody in the audience at our last meeting, but I do think it's important to do as much due diligence and make things as strong as you can here, and answer, questions that have been asked of us here to the best of our ability. And I do commend the staff and Mr. Pierrick, Mr. Francis, you worked on Memorial Day too? Did I hear that right? But I do think it's important to really take your time and do this to the best of our abilities here. So I too support that we move forward with option 2 and let the voters decide on this.
After listening to Matt, I've got to do a little history for just a second, so everybody knows what's really gone on in this town. And Richard Francis will know that I worked as co-chairman of SOAR for this community in 1998. And we passed it, overwhelmingly 70-something%. And they spent $140,000. Anyway, we beat them, and we passed SOAR. Canal Creek is brought up, and all the development we've got going on here was brought up by Mr. Matt. This Canal Creek has lost 3 times. Every time they come before us over the past 20 years, it's lost. But the council can't say anything till you had a public hearing. If you say something, they can challenge your vote, and you might not be able to vote. So we have to shut up and take all the arrows and things and calling us developers and everything else in the world. Then it loses. And so we've upheld the people's cry. SOAR, when mistakes were found and it was disqualified, I offered, this is what's strange, I offered, hey, I'll bring it back, we'll put it on. And they said, no, we want to do it ourselves and put it, go the hard way again. So we made the offer, city did, or through me anyway. But you guys did it the hard way, and I think you were successful. The issue we're facing tonight is not an issue. We're going to put this thing on the ballot. I already hear a couple of them saying that already, so I think that we've got this part of it gone. But when you talk about all the development we have going on in Camarillo, when we passed the growth control in 1983, that says we're going to limit it to 400 units a year. Well, you know how many we were growing at that time? 3,000 new units a year were being built back in 1980. 3,000. Everybody would cry blues if we had 3,000 going out there right now. Well, myself and a couple others put an initiative together, and we won. Cut it down to 400. Attorney told us if we go below that, we could lose in state court, for not taking our fair share. Thousand Oaks did the same thing, and we were both the same size. But they had loopholes in theirs. Now we're 67,000, they're 110. So who's grown fast, us or them? It was them. We've done an orderly growth that's helped us maintain our capital improvement projects here in town, bridges and other things. It's given us time to catch up, take a breather. But if you went too low, we could lose in court for not taking our fair share. So we've taken the responsible lead this council has. 4 years, there's only 40 or 60 houses built only from like 2009, 10, 11. There were very few houses built. Economy got better. The ones that were zoned already began building. Everybody said, we're building everywhere. Well, not really. The city's almost finished. It's almost done. So the scream and moan about the growth rate we're doing, I don't think is correct. And we've done our responsibilities. This board has, and we also, like you saw this evening, we had to okay things like senior housing, low-income housing, regular housing. We had to okay a mixed variety of units in the city by law, and so we're trying to do that. Same time, we're putting up berms and things to make sure it benefits everyone. And so tonight, we've got this back for you again, us again, and I guarantee you I'm going to vote for it to be number 2.
Your Honor, I'll make a motion.
Yes.
I'd like to make a motion to adopt a resolution submitting the ordinance to the voters at the November 8th, 2016 general election and directing the city attorney to prepare an impartial analysis of the measure. And I'm going to include that we are going to have you add those 6 words.
I'll second the motion.
I should mention that they're already included in the ordinance that's in your packet.
Yes.
Okay. I just had to
We
make
need a
it
second now.
perfectly
I'll
clear.
second the motion.
Kevin, you got a second? Okay. We have a motion, a second. Any other comments? Please vote. That motion passes 5-0. Mike, can we take a 5-minute break? We're going to take a